case number 113881, State of Kansas v. Derek Buell.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Derek Buell. May I please have 3 minutes for rebuttal?
3 minutes is granted.
Okay, batting cleanup, I suppose, here on all of DECOM. I think I kind of maybe want to just start at the beginning because I feel like throughout the morning we've jumped around a lot. And what we start with basically here is how do we decide things in Kansas, extra-jurisdictional convictions, how they're treated. And we start always with 216811E. And the first part of that actually is whether or not it's going to be treated as a felony or not. In this particular case, doesn't matter because, again, this is decided based upon the other jurisdiction. In Florida, we're dealing with felonies. So we're dealing with felonies. The question comes in to the other half of 216811E, which is whether or not the Kansas crime is comparable to a person felony. Now, there's been talk of 6811D, and particularly in the prior case of 6811D is all that matters when it comes to burglaries. The thing is, you don't ever look at 6811D unless you have a burglary. So again, you start with 6811E. Is it maybe a burglary? If so, we go to D. And in my case, and the case prior to mine, the bottom line is these were never burglaries to begin with under any sort of comparability analysis. So because they were never burglaries, we're not going to move to 6811D to even look at whether or not a dwelling was involved. So coming back to, I guess, the big question for all these cases today is what does comparable mean? And I've kind of coined the pre-DECOM test is the horseshoes and hand grenades test because my grandfather used to love saying that, close enough is good enough when it went horseshoes and hand grenades. Now, in DECOM, however, the court kind of made clear that to be constitutional under the Sixth Amendment, you can't be just close enough for horseshoes and hand grenades. You need identical or narrower elements. Now, Justice Stegall, you've continually been asking questions about whether or not we're in a statutory realm or a constitutional realm. Well, the answer to that is both. And that comes to the doctrine of constitutional avoidance, which goes back to, I just love the case name, the Charming Betsy. If we have a constitutional way of reading a statute, that's the way we have to read it. So, if comparable means horseshoes and hand grenades, then we actually are necessarily going to ultimately be looking at factual findings in another jurisdiction when the elements are not identical or narrower. And if we are doing a factual finding, that's when Apprendi is implicated. And the Mathis court pointed that out, that it's not just the existence of a prior crime we're dealing with, because that would be okay under Almendarez-Torres, but we have to look at what the facts of those underlying convictions are. So, on the other hand, identical or narrower as the test for comparability, in that situation, we only look at elements. So, if the extra-jurisdictional statute, and I say extra-jurisdictional because we're not just, in the grand scheme, we're not just dealing with states. We can also be talking about municipal ordinances. We can be talking about federal crimes under the UCMJ. So we're not just talking about state convictions. We're talking about anything extra-jurisdictional. So if those elements are broader, we never know if that could have been a crime in Kansas without looking at the underlying facts. For instance, we were talking, the prior case was talking about criminal trespass, the distinction between a criminal trespass and an actual burglary. Now, one of the cases cited below was Williams, which was a case before this court in 2014, so before these issues were really starting to get developed. And in Williams, the Ohio statute was a lot like the Florida statute here, where it just says any offense. If the underlying intent upon the illegal entry or remaining within is any offense, then that is good enough. Well, in that case, the appellant was arguing that we could use an evidence-based inquiry, and the court said, no, we don't use, correctly said, we don't use an evidence-based inquiry. And then the court said, went on to say, well, without using an evidence-based inquiry, the question when determining whether it's an aggravated burglary or a burglary is whether or not it's a dwelling. And that's true under 216811D, but the real question comes to whether or not it's ever a burglary to begin with. So take, for instance, and the question in the Ohio statute at issue was whether or not the intent to commit a theft in Ohio was the same as intent to commit a theft here. And in Ohio, a theft does not require that intent to permanently deprive that we have in Kansas. So take, for instance, a situation where that element is lacking in Ohio. What would we have here? Well, we would have some sort of crime for breaking and entering, which would be a criminal trespass in Kansas, plus we would also have a criminal deprivation of property. And as I think everyone should know here, burglary in Kansas with intent to commit a criminal deprivation of property is no burglary at all. It's not a crime. It can be a different crime, but it's not a burglary. It would just be a criminal trespass and a criminal deprivation of property. So bringing that back here, we know that in that sort of situation, we would not be treating it as a burglary. It doesn't matter if it was a trespass onto a dwelling or not. It's irrelevant because you're just not dealing with a burglary at all. This is similar to this case when we're talking about a Florida burglary. And it's even more problematic. In my 609, I point out, Florida doesn't care what the underlying offense is. As a matter of fact, they have a statute that says if you enter stealthily or without the consent of the owner or occupant of the structure, it's presumed that you intended to commit some offense inside there. And the Florida case law specifically says you don't have to allege that offense in the complaint or indictment, and if you actually do, it is mere surplusage, nor does the jury in the jury instructions have to find what that actual offense is. It's just irrelevant. So it could very easily be the situation, much like I was talking about in Ohio, where you could have some misdemeanor or anything else as the underlying intended offense in Florida. And again, you never know because you don't have to allege that offense in Florida. That would be the intended crime, which would, in Kansas, that would not be a burglary at all. So we know there that any Florida burglary is going to be indivisible, and there's just no way to know whether or not it is or would have constituted a crime in Kansas without looking at the facts. If we look at the facts, however, that's when you dive into the Apprendi problem. So the only way for the term comparable to be, well, the definition for comparable necessarily has to be identical or narrower. Otherwise, it's going to be something that implicates a constitutional problem. And that's where you have the doctrine of constitutional avoidance coming in.
I understand the argument, but if I could drill into it a little bit.
Sure.
What if the legislature just said, the Kansas legislature just said, any defendant who has in their criminal history a conviction for violating Florida statute 810.02 shall be deemed to be a person felony?
Wouldn't be a problem. And that for the same reason that the legislature can call identity theft a person felony at one point, and then it can be a non-person felony.
So that
doesn't matter.
That doesn't
how the
create a
legislature defines it.
constitutional problem.
That doesn't.
It's the fact finding that creates the constitutional problem.
If there is fact finding, and the only way to avoid fact finding.
But a court could construe or interpret the word comparable or comparable, to include 810.02 as a matter of law. From your perspective, that might be very poor statutory interpretation.
No, I don't think
but there's no constitutional problem with that, is there?
For the court to interpret it that way, that is a constitutional problem.
Why?
Because the court is not the legislature. The court can't judicially legislate what things mean.
I understand.
And if that's the case,
you're saying that's very poor statutory interpretation, but we don't run into a Sixth Amendment problem, is what I'm saying.
no, I think you certainly do. And you also run into, as the 609, that's the problem now, having the short 609, concise 609 problem, is Johnson came down later, and Esquivel Quintana has come out since, further pointing out you have vagueness problems unless you have a definition. You can't have the court out in Grant County saying a burglary in Florida is comparable and the court down in Lynn County saying it's not. I mean, the vagueness requires the defendant to know what the punishment's going to be. And the reality is, you can't sit and have...
So you think the constitutional problem there becomes sort of a due process vagueness problem?
It would be. That's another constitutional problem that would arise unless you do identical or narrow elements. I mean, the difference, again, with your hypothetical is that it's not, for the legislature to do something, they would be defining, and they could. It would be very unwieldy for them to go through every burglary statute, and this doesn't implicate just burglary. Because the reality is, and I've many cases out there right now pending. Certain states have different elements to their crimes than Kansas. I mean, that's the reality. The UCMJ has different elements to some of their crimes than Kansas. Batteries are not the same everywhere. Some assaults specifically. Some assaults are attempted batteries. Some assaults, like in Kansas, are placing someone in imminent fear of bodily harm. Were it a battery assault, just an intended battery, then the victim never needs to know if they're actually in apprehension of bodily harm. It doesn't matter what the victim thinks. Whereas the other assault, it does, as in Kansas, it does require. So those aren't comparable. It's broader in other statutes. And this is, for all statutes, this is what DECOM, Mathis, etc. means. I also want to just point out that I thought this was pretty easy back when I'd written these briefs until Mathis came down. And I've had a couple other cases in the Court of Appeals pending where Mathis has made me rethink how simple it is, because Mathis now says, I used to think divisibility, basically, if you had an enumerated list of alternative means, what Mathis would now call it, but an alternative list, like, for instance, vehicle, dwelling, structure, and that was in the statute, then probably the statute was divisible, and you could go back on a modified categorical approach. But Mathis has said that's not quite right now. Mathis says, no, those could be alternative means, those could be alternative elements. Because in Iowa, they had the exact situation where they would have read to me like they were alternative elements in the same way as Shepard in Massachusetts had different kinds of conveyances. And they said, no, you have to actually look at what the state law is. And in Iowa, they've said those are alternative means. And so because they're alternative means, rather than alternative elements, it's not divisible, and so they couldn't use in that particular situation the Iowa statute. And as I pointed out earlier, Florida doesn't care what the underlying intent is upon the illegal entry, unlawful entry or remaining within. So because of Mathis, that would mean Florida courts have held that it's not divisible, whether or not you can't look at what the actual underlying felony was.
The way I read Mathis is, I know it tries to distinguish between element and bare facts, and it doesn't dovetail really with our alternative means and options within means for our unanimity cases. But the bottom line is that I get from Mathis is, if the jury were not required to be unanimous in finding that particular fact, then it's not an element. And the sentencing judge in Kansas can't find that fact, whether it's admitted or not. Even if the defendant admits it, if it's not a fact that has to be found by the jury unanimously, then it's not comparable.
That's how I read Mathis also. I'd also point out, if you go back to the mother of this line of cases, which I think the mother of them is Apprendi, but if you go back to DECOM, in DECOM, they're looking at the California burglary statute. California doesn't require an unlawful entry. They just care about whether you're there to commit a crime or a felony or actually a felony in therein. And in DECOM, it turns out that at the plea hearing, the factual basis was that he broke into a grocery store. And he did not, and the court pointed out that he did not object to that. So thinking about that, the facts were brought up. I mean, in Kansas, we know under the guilty plea statute that entering a guilty plea to all the well-played facts, you're admitting them all. But they said in DECOM, it's not an element whether you break in or remain within. As a matter of fact, there could be any number of reasons why you don't pipe up and object to that. You know, it's part of the plea deal. You don't want to make the judge mad by saying, wait a minute, I didn't actually break in. Any number of reasons that was pointed out in DECOM why you wouldn't pipe up about that. But it doesn't matter because that's not an element of the crime. And because California lacked that element, it necessarily is broader. You're only looking at the actual statutory elements. So Mathis is exactly in accord with that. Unless it is a specific statutory element, you're not dealing, it's not something you can look any further to find out. So I was hoping there to cover the main things that were kind of, I hope I didn't miss it. One last thing on your hypothetical, Justice Files. In the last case, you were questioning whether or not adding a misdemeanor assault to the list would change things. And I'm sorry, I'm running out of time a little bit. But under Mathis, I think it could go either way, and it would depend on, Mathis gave three different ways. Laid out three different ways. You look at the court decisions, you look at whether the statute has different punishments. So if it was a burglary with intent to commit assault, was a different punishment than a burglary with intent to commit a felony, then you would have an alternative element situation. And the third was, looking at the actual indictment or complaint, and if they generally in those documents shotgunned out the general statutory language, that goes against it being an element, as opposed to electing a single element points towards it being an actual element as opposed to a means. So under Mathis, it would seem that it may or may not be divisible. It all depends on whatever the jurisdiction's law is at that time.
But that just, whether it's divisible, just means how you get the elements to compare. But under either way, how is that going to pass muster?
It doesn't
even
unless
if you get back to the modified categorical, you still lose, or the state loses because you've got the assault in there. It doesn't compare.
Yeah, the bottom line is, that's whether or not it's divisible. It could be
If it's not
under
divisible,
Esquivel, they say no.
You just compare the elements.
Exactly.
And
Right,
it's
that
not
was
going to
my-
pass muster there because they don't compare.
That was my point. I was just trying to say,
Yeah.
how close does it have to be to be comparable? And if
They-
it's just one crime, is that sufficient to make it comparable or not? I suspect that makes it broader, even in one pretty minor way, or could be minor, but.
I would think I agree. In this case, I think it's irrelevant anyway, because we have an overly broad statute. There's no way to narrow it at all, particularly in Florida. But
Yeah, I understand under this. Yeah.
the bottom line is that the horseshoes and hand grenades test has to go under the doctrine of constitutional avoidance. Otherwise, you end up with a problem under DECOM and Mathis and its progeny, and Apprendi and its progeny. So,
Do we have any further questions? Thank you, counsel.
Good morning. May it please the court. The state appears by Assistant Solicitor General Jody Litfin. Your Honors, I don't know that I'll have anything new to add, or if I'm just going to echo what my previous prosecutors said here today. I think our position is clear that in this case, 216811E controls. The state's position is that this comparability analysis works. It's allowed. And if you compare the Florida burglary statute with the Kansas burglary statute, they're comparable. It stops. Here, there was no contesting that it was done to a dwelling, so that makes it a person felony here in Kansas. I will point out, though, I think that here it's a little bit unique in that we have State versus O'Connor, in which this court, after DeCamp came out in 2013, this court came out in 2014 saying explicitly that at least they were dealing with third-degree burglary, which is not what we're dealing with here from Florida, but it's closely comparable to burglary of a non-dwelling in Kansas. And here, in our Court of Appeals panel, in their ruling, they said, this court has stated that in O'Connor, Florida, this court has held that Florida burglary is comparable to Kansas burglary. So I think that's a point that this court has already addressed, and that if we are looking at this statutory analysis of is it comparable, we can rely on this court's previous precedent, and unless this court goes to an identical or narrow test, this court's already determined that these two are comparable, and then we go to the dwelling, non-dwelling element.
Where is your adversary wrong when he says if we construe 2168.11E in that manner, close enough is good enough for government work, that we run afoul of Sixth Amendment right to a jury trial as set forth in Apprendi and DeCamps, Mathis, and they all indicate that there's Sixth Amendment constitutional overtones at the very least, if not directly applicable.
I think what the state would rely on is the fact that those cases are interpreting the ACCA, and here 6811E is Kansas statute, and we don't have to go into all that Sixth Amendment analysis and those undertones or underpinnings or whatever, because we're just doing a strictly statutory analysis between whatever crime you're dealing with here, the Florida crime for burglary, and whatever crime in Kansas it's comparable to. So it's a legal comparison where you're not getting into any factual findings. So if they're comparable, which I know this court has an issue with, that's really broad. What does that mean? Closest approximation, is that good enough? But if it goes with what the court has said previously, that is good enough, and they don't have to, even the intent elements do not have to match, don't have to be identical. So I don't think we even go down that road. It's just a strict legal comparison of two statutes.
Is the statute ambiguous?
No.
So if it's not ambiguous, what is your best plain language argument? Because again, I mean, we've spent all morning talking about what's comparable or what's comparable and what's not. How is it just sort of not in the eye of the beholder?
Well, I think
which strikes me as just sort of the quintessential definition of an ambiguity.
I think we have to look at what this court has said previously in Williams and in Van de Voort and the other cases that have defined that term comparable.
So you would ask us to look to our prior gloss rather than just to the language of the statute itself.
Yes.
Okay.
And I don't know if I want to muddy the water any further, Your Honor. I don't believe I have any further presentation.
Any more questions? Thank you, counsel.
Thank you.
I almost always regret this. But just to point out, with respect to O'Connor, that was not analyzing the specific intent issue. That case was actually Mr. Minahan's case before he left for Johnson County. And it was raised in statutory terms of whether or not it was the correct burglary. I happened to do a supplemental brief, I think, in that raising DeCom. The court said, no, this court said you win on the statutory argument. By the way, even if you didn't, looks like you might win on DeCom. So it wasn't really a DeCom analysis. But more importantly, it was only analyzing the dwelling aspect of things. It wasn't looking at the underlying. No, it was not raised in terms of the underlying specific intent. With respect to, again, the difference between the legislature making a statute that says we will treat all Florida convictions under 81002 as person felonies, the difference is that's an operation of law as opposed to a fact, whereas So we look to the law. What's the law say to do? It says to do this. As opposed to a judge saying, well, is it comparable or not?
But if
Well,
the comparability determination was made as a matter of law, as a matter of legal statutory interpretation, how is that any different from the legislature just simply writing it into the statute?
Again, the two problems, there's no predictability as to that, creating the vagueness problem.
So you have a different constitutional problem at that point.
But I also think you're still necessarily looking at facts.
You think that
When
that,
you do
even
that.
if it's characterized as
You may
as a
call it-
determination of law, you think it's predicated on fact-finding?
Paraphrasing Mathis, when the Mathis course said, we don't care what label you give a crime or what a state calls a crime, it's the elements that matter. Similarly here, you could call it a matter of law, but you're not really it's not really a matter of operation of law. I mean, otherwise the state would be able to articulate what, with respect to when we were talking about Oregon, why, and sometimes it's going to be meant as if in some situations in Oregon it's going to be a person felony, some situations it wouldn't be a person felony, wouldn't actually be a burglary here. And the whole point again with the legislature was if it's dangerous. Well, but if it really, a criminal trespass when someone's present would seem to have the same sort of danger. So these are all sort of create a legal fallacy as to what we're really doing. You're really looking at facts. And finally, the state tried to say that DECOM and the like are only dealing with the Armed Career Criminal Act, and that's why in my brief, my reply brief and my petition, I point out Voisin, which had nothing to do with the Armed Career Criminal Act. It was having to do with a felon in possession of a firearm and the interpretation of whether or not domestic batteries would, because in 35 jurisdictions, domestic batteries can either be reckless or intentional. And the court said, no, all those, that is a divisible statute. If we were to hold as I believe the petitioner in that case wants, then we wouldn't be able to use any of these because it would violate DECOM. So wait a minute, DECOM does apply to things outside the Armed Career Criminal Act. So any argument that DECOM is restricted to the Armed Career Criminal Act fails in light of Voisin. So.
Do we have any further questions? I see none. Thank you, counsel. Well, thank you both for your arguments this morning. Quack will take this matter under advisement.